Alrighty, well, hello everyone, and welcome to the Lomita Chamber of Commerce Employment Law Update for 2022. We're already at the end of March, and can you believe it? April's just around the corner, so we're starting to get closer to that midway mark for the year. And I'm super excited to have you all here and our speakers and guests as well. It is kind of apropos, I think, that today is National Mom and Pop Business Owners Day. And I'm really honored and excited that we have some fabulous resources available to those of us who are mom and pop business owners or small business owners and entrepreneurs. As we know, it's quite a bunch of different challenges that we love and are sometimes stretched by in running a business, whether we're a solopreneur or we have 5+ to 500 employees. And so it is our goal here at the Lomita Chamber to bring these educational programs forward to our membership and our business community at large, at least 2 to 4 times per year. So happy to kick this one off with our guests. My name is Heidi Betzine. I'm the President and CEO and founder of the current Lomita Chamber of Commerce, but really we're excited to offer these resources to you, covering a bunch of different topics today. There's a lot of things happening that our guests, Scott and DeAnn from Chase Law Group, will be covering in terms of what you need to know. And so I ask you to please, if you have questions, put them in the chat. We are going to have a lively Q&A session after they talk about some of the updates. So if anything is unclear or you don't understand what an acronym means, please hold that thought and put it in the chat, and we will definitely get your questions answered. So today we're going to cover a number of things, including minimum wage. What is the new minimum wage requirements, retirement savings plans that you're required to have, sick leaves, family leaves, independent contractor versus employee. What does that look like? And we also have some resources here in the audience that can help you with things that might be of benefit to your employees, whether that be a retirement savings plan or insurance plans, life insurance, things like that. So without further ado, I'm very excited to introduce Chase Law Group and welcome them as our speakers today. We have the founder and owner of Chase Law Group, DeAnn Chase. I've known DeAnn now, I think, for 10 years. Could it be that long, DeAnn?
Or more at this point. Yeah, crazy.
And just taking off my chamber hat for a minute and putting on my small business owner hat, DeAnn has helped me quite a bit in doing those things like the ticky-tack, keeping your corporate minutes in order. If you haven't done that, you need to talk to DeAnn. Contractual issues, and really just talking about what to do with my businesses, starting off as an S Corp or a sole proprietor to converting to LLCs and having all the DBAs and other acronyms that go along with that. So DeAnn really makes it clear. She's been practicing law for nearly 20 years. Of course, Chase Law Group is now the name of her firm, but interestingly enough, she started her law firm under South Bay Business Lawyers. So that just shows you how she has roots in the South Bay. And that's really who she caters to, not only in South Bay, but businesses throughout Southern California. So she works with entrepreneurs, business owners, and professionals like all of us to get those legal foundations strong and getting the structures in place. And of course, she's seen just about every courthouse in Southern California through litigation. And really keeping things simple is what I think DeAnn, your strong suit is really walking through the options and making it very clear for a business owner to be empowered to make their own decisions and how they want to run their business or handle some of those sticky situations. Of course, DeAnn has a number of accolades, Woman of Entrepreneurship Award from Comerica Bank and the LA Lakers. She's very active in the Manhattan Beach community, including the Chamber and Kiwanis. And get me right, is this true? You were the first female president of the Kiwanis Club since its inception in '56?
The Manhattan Beach chapter, yes.
So she's a Kiwanis sister, so we welcome her here, and of course leads the Chase Law Group. Also joining us is Scott Leiner. Scott is an associate with DeAnn with Chase Law Group. He's an employment attorney that has over 30 years of experience, and I love this, Scott. You talk about your wheelhouse being helping businesses navigate California's complex employee-friendly laws, which is very interesting, I think, to note in terms of the environment that we are in as California business owners and how the laws do tend to be very employee-friendly. So what do you need to know as an employer to make sure you navigate all of those things delicately? And of course, He handles the litigation, he handles the mediation, arbitration, things to resolve disputes with employees as they come up, also how to handle certain situations as they come up, and all those things you guys should be thinking of doing, like getting your employee handbooks and policies up to date. You're going to hear about some of the laws today that you'll need to make sure you do that with, and really holding the hand of our employers and businesses out there to not have to go to expensive and costly litigation if you can avoid it. So you guys have a wonderful wealth of resources here. We also have a special guest, Andrew McReynolds from Monarch Grove Wealth Strategies and Insurance Solutions. He's here to answer any questions that come up during the Q&A that you all might have with regards to retirement savings programs. This is a requirement through the CalSavers program that Scott's going to touch on today. But Andrew is here to be a resource if you have any questions that kind of go in that direction. So get those questions ready, put them in the chat, and we're going to start with you, Scott. So let's go ahead and get going. If you want to share your screen, you have the floor.
Great, I will. Thank you. Bear with me. Okay, terrific. Great to see everyone and glad you joined today. Thank you, Heidi, for the wonderful welcome. And thank you to the Chamber for having us, allowing us to speak with you today. I'm going to start it off talking about some of the new employment laws that you need to be aware of. And when I'm completed, I'm going to hand it over to DeAnn, who's going to talk about independent contractors, AB5, and all of that. So let's jump into it. One of the things I'm going to talk about today, or a few of the things, are some changes in the law that occurred right before the beginning of the year, other laws that came into place January 1, and a few others that have come into place since then, and then finally things that are coming up. So I'll have you prepared for what's happened and what's going to happen in the near future. First thing we're going to talk about is minimum wage. Minimum wage, hopefully everyone's aware, has now moved in California to $15 per hour for employers with 26 or more employees, and $14 per hour for 25 employees or less. That's going to be increased, strike that, I'm sorry. In Los Angeles, be aware though, because Los Angeles is the tricky part here. Los Angeles is $15 per hour, regardless of the size. And you might think because your business is not in the city of Los Angeles that you don't need to be concerned about that, but you do. What the city of Los Angeles says is that any of your employees spend 2 or more hours in any week in the city of Los Angeles performing their job, then they must be paid the California minimum wage. So again, you might think you're out of trouble because no issues there, because no one's working in the city of LA. But the bigger problem, or remaining problem, will be as it relates to anyone who might be working remotely. And if they live in Los Angeles, then you need to be, and they're working remotely from home, they need to be paying them that increased $15 per hour. So be aware of that. Take a look to see if you have remote employees, double check to see where they live and where they're working from, so you don't get in a position where you're not paying them that important city of Los Angeles minimum wage. Note that increases the minimum wage in Los Angeles to $16.04 July 1st. And the reason for that is it's tied to the consumer price index. So you'll see annual changes as well of strange increases along the way. It's important that you pay minimum wage for many reasons. Not only is that such what people are entitled to, but you also, by failing to pay minimum wage, subject yourself to penalties that come about. By failing to pay minimum wage, you're subjected to liquidated damages under the labor code, where you not only have to pay the difference between what they weren't paid and the actual minimum wage, but also the equivalent of that in liquidated damages. Plus, if the employee no longer works for you, you have to pay them waiting time penalties up to 30 days. And that's not a month, it's 30 actual days. So even at minimum wage, that can amount to over $10,000 owed just for that. And you also then have other penalties, including wage statement violations and then attorney's fees. So very important to make sure you double check that you're paying the right minimum wage for your employees. And don't just assume because your business is not located in Los Angeles that you're free from that. Okay, moving along to some other changes. So you may or may not have been aware, but in 2021, CFRA, California Family Rights Act, and that provides up to 12 weeks of unpaid leave for an employee or a family member for their own serious health condition. This is unpaid leave, although there is state disability available. So that used to be 50 or more employees in the state of California, but significantly and dramatically, that was reduced to 5 or more employees. So if you have 5 or more employees, you must provide this important leave to your employees. And that was also expanded a year ago to include a wider net of potential family members. That includes a spouse, a registered domestic partner, a parent, a child, which includes an adult child, a child of a registered domestic partner, a grandparent, a grandchild, and a sibling. And just in case they thought they forgot anybody, this year they included parent-in-laws. So it's pretty much anyone you can think of in your immediate family, not necessarily cousins and aunts, but everybody else. So this is an important element to be aware of. It's important that when someone is going to take leave, you're not entitled to all the details of their leave. It's enough that if they say they have a condition, that they need some time off, they do need to get you a doctor's note. You're not entitled to the underlying condition that they have. And as long as the doctor states that they're under their care, then you're obligated to give the leave. And then the last piece with this relates to that you need to confirm in writing that the leave they are taking is in fact this CFRA leave. If you don't notify them that that is the case, it won't apply and they'll still have whatever is running on that 12 weeks. And the last important piece relating to the CFRA expansion is mediation rights. So for employers between 5 and 19, I'm not sure why they stopped at 19, but now mediation must take place. The parties could, I suppose, they decided not mediate, but even if an employee doesn't mediate, and they'll be notified typically by an agency that they have to engage in mediation. But if they refuse to and go to court, you can still compel them and potentially even get a stay if we're at that position to require that they go to mediation. So a new piece of that. Okay, so that's the CFRA expansion. Moving along to a few additional important new employment laws. The first is there are new CalOSHA penalties. Briefly, there's an enterprise-wide violation that now exists. So if you have more than one location, and the CalOSHA finds that there was a violation there, there's a presumption that the violation occurred elsewhere. So just be aware that you've got all your safety issues taken care of there. And also a new penalty, egregious penalties, that's the higher penalty in value that can be ruled against you. So just make sure if you haven't looked recently, your CalOSHA compliance, that you do so because of these new penalties. The additional change has been criminal penalties for wage theft. So theft of wages under AB 1003 means the intentional deprivation of wages. What this basically means is if you fail to pay someone minimum wage or other wages that they're owed, or if you're a place that receives tips, you've taken some of the tips that they were entitled to. Previously, this used to be a misdemeanor only, but now it can rise to the level of grand theft to felony. I would guess that in order for it to rise to that level, you really would had to have engaged in some intentional conduct to establish that, but don't assume just because you were unaware of the law that that's enough to prevent you from not only facing the civil liabilities of failing to pay wages, but also the criminal. So again, just demonstrating the importance of why you need to comply with California's various wage laws because of these tremendous penalties now being criminal under the law. Next, we're moving to changes to the non-disclosure agreement law. So non-disclosure agreements come up when a dispute has arisen or a claim has been made by an employee and you want to settle it, you want to wrap it up. So when you do that, typically you're paying them some amount of money, and even if it's nominal to make the claim go away, you're going to have a settlement agreement. And what you're going to have is an agreement, at least in the past, that precluded them from talking about the claim or the amount and whatnot. But the law has changed now. So after the Me Too movement first started up a few years ago, at least publicly, it applied only to sexual harassment claims. But that's been expanded by the new law to include any unlawful act. So you can't prevent someone when you settle a claim with them or resolve a dispute with them, which involves a settlement agreement. You can't prevent them from discussing unlawful acts, whatever that may be. You can, at the person's request, keep their name to be maintained confidential. And of course, you also can ensure and keep the amount of the settlement that's being paid confidential. But you can't require that be, again, that any unlawful acts, they're allowed to discuss what happened, and you can't keep that confidential, which was an important reason why a lot of people settled cases in the past, that it didn't want it out in the public. but that piece has been taken away. But again, you still can keep secret, confidential the amount that actually was paid. So that's your non-disclosure agreements. Another new thing that happened in February of this year was paid COVID leave. This applies, though, to employers with 26 or more employees, and it applied retroactively beginning in January 1. So even though it came into law in February, they said if anybody took leave due to COVID from the beginning of the year, you had to go back and pay them. So if that's happened at your business, make sure that you take care of that. And then all the way to September 30th. This covers both full and part-time employees, although part-time employees will only get a pro rata share of the amount of leave that they get, and that's up to 80 hours of paid leave. And in doing this, unfortunately, the state didn't provide a tax credit. The prior paid leaves allowed employers to have a tax credit. That's not the case anymore with this type of leave. It only runs the end of the year, and hopefully with the status of the pandemic, there are fewer people who come down with COVID, but be aware that if they come down with COVID, there's two different buckets of available paid leave that they're entitled to. There's 40 hours of paid leave if they themselves or a family member they have to care for test positive. So a total of 40 hours, or again, less if they're a part-time employee. Separate from those 40 hours of leave, they potentially can get up to another 40 hours of leave for these various issues. If the employees experience COVID-19 symptoms and are seeking medical attention, so this is if they're not feeling well and you're concerned that they have COVID or they are, that could fall into that situation. If the employee is subject to quarantine, they're under a healthcare provider's instruction or part of the CDC or local guidelines, which is the case, there still is requirements about quarantining if someone gets COVID, to attend a vaccination appointment. So if they have to get vaccinated and they tell you that, you need to make sure that they're paid for that time, as well as a family member, or if they're getting a booster, or if caring for a child who goes to a school and they have to take time off because the kid is unable to be in school. So it's important that you are aware at least about the potential for paid leave, and that these are all the reasons. And it's not simple to follow. I would suggest reaching out to us if you have any questions about this. You can get kind of complicated. Other particulars related to this paid leave is that when you do pay the leave as part of their paycheck, unless they're not working, you need to note on the pay stub that this was for this COVID leave. If you don't have that, including the time remaining, then it's not going to count towards the amount of hours that they're entitled to, and you're going to owe that on top of the leave that you're otherwise paying them for. You can request a medical note from the doctor if they're being treated by the doctor, but again, be careful not to ask for more information and don't pry too much into their privacy. And then lastly, be aware of potential retaliation claims associated with someone who's taking COVID leave. Most employers know that they shouldn't do that, but sometimes it comes up when a performance issue comes around shortly after they took leave, and just be aware that even if you didn't intend to retaliate, someone could make a claim. So again, seek employment counsel if that type of situation comes up where you think there might be a need to suspend or terminate an employee shortly after they take COVID leave, so we make sure you're adequately protected. Okay, moving along to significant changes in arbitration agreements. This is a big one. So in the past, many employers would consider and consult with employment attorneys to decide whether or not, as a requirement of employment, that they would require their employees to enter into arbitration agreements. And this was fine for many years. And as long as the arbitration agreement complied with the law, which required that it be procedurally and substantively conscionable, which basically means that all of your claims against the employee and all of the employee's claims against you are going to be included in arbitration, that you as the employer will pay for the cost of the arbitrator, not necessarily employees' lawyer fees, although they recover that if they prevail, but just the arbitrator's fees, which can be substantial. And other situations and circumstances that can be covered in the arbitration agreement. But that changed, and some of the changes pre-existed this new federal law. But first I want to discuss the new federal law that President Biden signed into law early this month, barring arbitration of sexual assault and sexual harassment claims. So this is going to invalidate any existing agreements that waive employees' rights to join class actions or to bring sexual assault and sexual harassment claims in court. But it didn't apply to any other types of these DFEH or EEOC claims. However, already existing on the books was California Labor Code section 432.6, which basically prohibited any agreement entered into after January 1, 2020. So almost for the last 2 years, any agreement after that, you couldn't enter into arbitration agreements mandatory. They can be voluntary on any of the FIHA-based claims or the labor code, which is most claims. Sometimes there's a tort claim like invasion of privacy or wrongful termination, which are tort claims, but anything relating to harassment, discrimination, or claims for wages, you can't, under this law, you couldn't require them to arbitrate unless they voluntarily entered and did so. However, recently, interestingly enough, in a Chamber of Commerce decision this past fall, there was a decision determining whether or not the Federal Arbitration Act preempted this California law. And an en banc decision made by the Ninth Circuit in a 2-to-1 decision, barely, they determined that the federal law didn't preempt this California law. Although they made a weird decision because they basically said that employees who enter into agreements there aren't criminal penalties. There's criminal penalties associated with requiring someone to enter into this type of agreement. There aren't any criminal penalties for that scenario, but if you fail to hire someone or terminated them because they refused to enter into the agreement, then there were penalties. So it's a strange result that came out from the court. The most significant thing is the status of the law is now that you cannot and should not require employees to enter into arbitration agreements associated with their employment. You can do it voluntarily, and if you really want this, you should work with a lawyer to ensure that the language is in there, that it's clear that this is voluntary and not required as part of their employment. And this may change. This may be appealed to the broader Ninth Circuit Court. This could go to the US Supreme Court as other circuits throughout the country reach different decisions regarding whether or not arbitration is preempted by the federal law. So we'll have to wait and see. But for now, if you have an arbitration agreement, take a look at it. If you don't, then I'd recommend you proceed that way. If you really want to have arbitration, then make sure the language there is strong, that it's voluntary, because you want to avoid the last piece of it is any retaliation claims. You don't want someone making a claim that you terminated them or didn't hire them because they refused to enter into this type of arbitration agreement. Okay, turning to our last piece, which is about CalSavers, and this is coming up. All employers with 5 or more employees have to register with the state to provide retirement benefits, retirement plan, I should say, for their employees. This was designed to provide some retirement plan for the 7.5 million people who don't have access, or at least haven't been able to save for their retirement. It's solely operated and maintained by the state of California, and it's structured similar to a Roth IRA for employers that don't offer any retirement plan at work. Alternatively, you can choose to select your own plan. You don't have to go with the state, but you have to certify whatever plan you decide to go with the state. So what are your responsibilities? So you don't have to contribute any money to the CalSavers plan, but you do have to register your employees. You have to go to the website on CalSavers. And it's a very, at least on the face of it, a very helpful website, and they have people there to answer your questions. And I'd recommend you do this sooner rather than later, because as it gets closer to the deadline of July 1, there's going to be a lot of people asking those questions, and you're going to get closer and closer to that deadline. So you're going to have to register. You have to give a roster of the employees into the state. And then through your payroll, you're going to have, they'll deduct contributions from the employee paychecks and submitting them through the CalSavers program. That's really, I mean, that's simplifying, but that's really all your obligations are. The rest comes down to the employees and what their obligations are. So first of all, they can opt out. They can go online and they can opt out and decide they don't want to participate in it. They want to keep the money and not save for retirement. That's their decision. They can increase their contribution percent. That's another thing they can do. It's automatically enrolled at 5% of their gross income. And then it's increased automatically 1% annually until they reach 8%, unless the employee chooses otherwise. It maxes out though at $6,000 per year for those under 50 and $7,000 a year for people 50 and over. And then there's a funds defaulter into money market, and when it reaches 1,000, it's transferred into an age appropriate target data fund based on birth date. So they have some interesting things in place there to help the employee navigate this, but that's really their decision to make. And wrapping up on this issue, additional considerations. when people who are not eligible for a CalSavers, or anyone who earns $135,000 a year if they're single, or $199,000 if they're married and filed jointly, they're not eligible and they'll have to opt out. You'll still submit their information to CalSavers, but they won't be able to. They'll have to opt out, and there'll be some process in there where, and if you know, you may want to find out from the state directly, CalSavers, what you need to do on that front to make sure that they're not registered. Generally speaking, and we can answer some questions about this if you have any during the Q&A part, it's kind of better if you have, perhaps if you have very few employees and don't anticipate staff high earners, that just CalSavers might work for you. Or if you don't want to be contributing, or if you have no desire to contribute to your own retirement through this plan. Possible disadvantages for sure is this: for CalSaver, it's post-tax dollars, whereas in a lot of 401ks, it's pre-tax dollars. So it may be more beneficial to have a 401k. There's no employer matching contributions that are allowed. And then the last thing is, with a lot of 401ks, there's loans that an employee can take against it. So that's not possible or available under CalSavers. So I'm going to turn this over to DeAnn now to talk about some of the independent contractor issues.
Okay, great. Thanks, Scott. Really appreciate it. So as Heidi mentioned earlier, Chase Law Group, we've been here in the South Bay for 15 years. And so we work with small business owners to help them develop their legal structures. But as the employment laws have become increasingly more difficult for employers to keep track of, we brought Scott on as of counsel to our firm. And as you can see, he's been a great asset to our firm for his years of expertise, and particularly on the nuances of all of these different laws that small businesses need to comply with. So on my side of things, I'm going to be talking a lot about independent contractor laws. So because we do work with so many small business owners, I just want to keep track of my time. I'm always being asked by small business owners, or told that they're hiring people as independent contractors, that they want to avoid hiring employees for all the reasons that Scott has mentioned and all of those laws. But I think what small business owners need to know in particular is that they may or may not knowingly hire someone as an employee thinking that they're hiring an independent contractor. So to that point, many of you may recall prior to COVID, in September of 2019, small businesses were really dealing with, and all businesses, I should say, throughout the state of California, we're dealing with the question of who qualifies as an independent contractor in the state of California. And at the time, there was a big uproar in our business community with regard to the passage of AB5. So just a refresher, AB5 was an assembly bill passed by the California legislature in September of 2019 that was based on a California Supreme Court case, the Dynamex case. And it created a new test in the state of California as to who qualified as an independent contractor and who was in fact an employee within the state. So the ABC test came about from the Dynamex case, and the California legislature put that into law. So as a refresher, the ABC test has 3 factors. All 3 factors need to be met in order for someone to qualify as an independent contractor. If all 3 factors are not met, that person is in fact an employee, and you then need to comply with all of the California employment laws that apply to having an employee in the state of California. And if you don't, then that person, if you hire an independent contractor who is truly an employee under the law, then that is called misclassification, and it can have a lot of penalties at many different levels. So, so you and your clients, if you work with business owners, really need to be aware of this three-part test. So, in brief, the part A says that the worker is free from the control and direction of the hiring party. Part B says that the worker performs work that is outside the usual course of the hiring entity's business. And part C says that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So it really is quite a lot that they've put into these three parts. But essentially, someone that you hire as an independent contractor should have their own independently established business. They should be providing the same types of services to other parties, and that cannot be the same as your business if you're hiring that person. So before the ABC test, there was the traditional, what was traditionally known as the right to control, right? And that's really something that business owners were more familiar with. They said, well, if I'm not controlling the how that worker is performing a particular job, then they're an independent contractor. And that was based on a previous California court case called Borrello. So what Assembly Bill 5 did is that it made changes in the labor code. And so if you read the labor code with regard to these independent contractor laws, the law is very, very complex. And as Scott has said, if you have any questions with regard to complying with these laws, please feel free to reach out to us. Because what you ultimately want to know when you're hiring someone is, what is the service that worker is going to be performing for your business? And you always want to start with, does it meet the three parts of the ABC test? If it doesn't, there are many, many, many exemptions that have been carved out in the statute for particular workers and situations. And the law reads that the ABC test applies, but in the circumstances where the ABC test does not apply, then the traditional Borrello test may apply. And Borrello involves the weighing of factors. And there are many factors. I've just listed a few on the slide. But it's more like I've always said, it's like the scales of justice. It's more of a weighing of if this and that sort of thing, to determine whether someone is an independent contractor. Some of those factors include who provides the instrumentalities, the tools that the worker is working with, how long, the length of the time for which the services are being performed. Is it payment by time? Are you paying by the hour? Are you paying by the job? Is it a 3-month project? Is it a 6-month project? The more open-ended it is, the more it looks like an employment relationship. And does the relationship terminate at will, which is more consistent with an employment relationship, or under the terms of the contract? For example, either side needs to provide a certain amount of notice. So I've listed on the following slides, just so you know, some of the most used and some of the critical exemptions, but do know that in every case, every exemption has many, many requirements that need to be complied with to make it apply. So when AB5 first came out, it was it created a huge disruption in the business community. And since then, sort of overlapping with COVID, the California legislature has made some changes. So there was a cleanup bill, AB2257, that passed in September of 2020. The intention at that point in time was really to clean up AB5, if you will, and so depending upon sort of who made the most noise in Sacramento, some of additional categories of workers were included. such as creative workers, including writers, photographers, videographers, photo editors, and illustrators. AB5 initially included, as some of you may recall, a limit of 35 submissions that someone would need to submit. For example, if they wrote for a newspaper and if they submitted more than 35 submissions, then they were automatically deemed to be an employee as opposed to an independent contractor. That's just an example of one of the changes that AB 2257 did, is removed the 35 submission requirement and built in other factors. The cleanup bill did not impact, as you recall, Uber and Postmates and all of those. That was handled by the California public by way of Proposition 22. We'll talk about that a little bit down the road here. But very critical for business owners to keep in mind is that there's a key business-to-business exemption that I'm going to talk about. There are some referral agency exemptions and professional services exemptions. And what the exemption means is that maybe AB5 does not apply, then you're exempt from, the ABC test. You may be exempt from the ABC test, which then requires you're still required to comply with Borrello. It does not mean that you automatically have an independent contractor. So these are some of the exemptions that are under the current law now. Licensed professionals, and there are very specific licensed professionals that are exempt from the ABC test. For example, a physician, surgeon, dentist, podiatrist, or veterinarian, a lawyer, an architect, and an accountant, for example. Our firm works with many different types of professional practice owners. For example, we have clients that are chiropractors, physical therapists, psychologists. They're not exempt. They continue to be bound, for example, by meeting that ABC or Borrello test. So that's why it's very, very important that you identify the class of worker who's going to be working for you. AB5 created, and now in 2257 in its current state, includes exemptions for a referral agency that provides referrals for many different types of services, and they're listed on the slide: graphic design, web design. You've got youth sports coaching, you have pool cleaning. In 2257 added interpreting services. So if that's for a referral agency that provides referrals and essentially connects a service provider with a potential client, then in that situation, the service provider is not acting as an employee of the referral agency. They are just essentially making an introduction. But it does not include, very specific services such as janitorial, courier, transportation, agricultural labor, in-home care, other things like that. The referral agency structure is not going to avoid an employment relationship. So as you can see, there are also other different types of situations where maybe you hire someone for your business. If it's a single engagement, and very specifically a standalone non-recurring event in a single location, and you're hiring people for that specific purpose, you may be able to qualify those individuals as that you're hiring as independent contractors. For example, maybe you have a catering company and you have an event where you are hiring staff for that purpose. But again, you always want to run this through an attorney to make sure that you're not, especially if you're hiring a lot of people, you don't want some of these people to say that they were in fact your employees if you hired them as independent contractors. There are the key exemption that can apply is a true business to business relationship. right? Where two independently established businesses are contracting with one another to provide a particular service or to have a particular relationship. And so that is called the business to business exemption, which is a process. So you say, okay, you have two independently established businesses contracting with one another. That means they're exempt from the ABC test, but then you need to meet the Borello test. And you can only apply the Borello test if you meet all of the factors that are listed here. So, they really do make you jump through a lot of hoops if this is in fact an exemption that you're going to be relying upon. And so an example is that I've listed in italics on this slide some of the changes that were made in the cleanup bill in 2257. One of the situations that really prevented some businesses from using this exemption after AB5 was that if the business service provider was providing services to the customers of the company that hired them, rather than to the company directly, then they could not use the business to business exemption. In this case, they added that that paragraph does not apply if the business provider provides services under its own name and it regularly contracts with other businesses to provide the same services, then they can be hired to perform services directly to customers. An example I had before AB 2257 came through to clarify this, for example, is I had a tutoring company as a client. The tutoring company was hiring tutors to provide tutoring services to its students. In that circumstance, because the tutors that they were hiring as independent contractors were providing tutoring services to the clients of the tutoring company and not to the tutoring company directly, they could not use this exemption. And then we looked at, for example, in that circumstance, tutoring services are listed under a referral agency situation, but a referral agency is a different business model, obviously, than hiring tutors to provide tutoring services. But I think that helps to kind of clarify what that means and what problem people were running into when they were trying to apply the business to business exemption. I think the important thing to note is that all of these factors must be met in order for you to apply this exemption. I generally recommend that if you're going to be hiring an independent contractor, you want that person to have their own independently established business entity, such as an LLC or a corporation. Now, 2257 did change the law to say that these business service providers can be a sole proprietor, but there's risk if you're hiring an individual that individual can make an employment claim, claiming to have been hired as an employee, as opposed to if you hire someone who has an independently established business entity that provides an additional layer of protection. Also, what this business to business exemption requires is that the company that you hire have their own business license, that they also have their own independently established business. In other words, they can't just be someone who's working out of their home and they don't do business for other people. They actually have to advertise and hold themselves out to the public as providing these services that they're providing for you to other people as well. So again, just kind of keep this in mind when you're looking to establish that sort of a relationship. And then, as I mentioned earlier, and it was all in the news, that we as voters voted on Proposition 22, because what the big picture in that circumstance is that the state of California wanted to tell Uber, Lyft, Postmates that their drivers should be employees and not independent contractors. And so, as we talked about, AB 2257 did not include these sort of what are called app-based drivers as exempted from the requirements. And so those companies went directly to the voters Proposition 22 was approved by the California voters in November of 2020. And so basically what that did is essentially carve out another exemption that allows these app-based drivers to be able to qualify as independent contractor. And of course, the voters required that certain additional benefits be given to those drivers. There have been a few other tweaks made, and there's AB 1506 and 1561, but really for the most part, this is the current state of the law, and definitely something to keep in mind as you go about your business. Thank you, Heidi. Thank you to the Lomita Chamber of Commerce for hosting Scott and I today. We know that we went over a lot of information very, very quickly, and we wanted to offer the chamber members, Lomita Chamber members who attended this conference, or anyone that you may want to tell about what you learned today, if they mention the Lomita Chamber of Commerce, Chase Law Group will offer a 30-minute complimentary consultation to talk about your business specifically.
Awesome. Well, thank you for that, DeAnn and Scott. And we do have some really great questions in the chat. The independent contractor thing, just kind of, my brain's a little fried. So rather than trying to figure it out on my own, I need to contact Chase Law. A couple things regarding that independent contractor piece, since we've got that as our last kind of topic. Valerie had asked whether church musicians are considered independent contractors or employees. So I don't know how that impacts or is impacted by AB5.
I'll take that one. So musicians were expressly exempted from AB5 by the legislature, but the Borello test still applies. So that those musicians, it's the multi-factor weighing test taking into all those considerations, some of which DeAnn showed, that would have to be evaluated. So they could very well be independent contractors if they voluntarily just play on the weekend and they pretty much just are otherwise doing other jobs, versus if they do other things with their church, and do they provide their own instruments and things like that. So there's a long list of things we'd have to evaluate, but that's kind of the short answer.
Okay, thank you, Scott. Naeem had a question. When there's a voluntary or involuntary termination, how much time does the employer have to issue the final paycheck? And can they be paid on the next payroll cycle? So is there a different timeline to pay if the termination was voluntary versus involuntary?
There is a different one. So if you're terminating employees, so involuntary, then you have to pay that employee at the time, the same day of the separation. On the other hand, if we're meaning by involuntary, the employee decides to leave and gives you little or no notice, then you're required to pay their final wages, including any accrued vacation or paid time off, but not including any paid sick leave, within 72 hours of their last day. So you got a little bit of time. You need to make sure that if they're paid by direct deposit, that you pay them that way. Reach out to them to see if they'll come in for the check. If you don't hear from them, make sure you get that check out to them to their last known address.
Okay, thank you. Christine over at Corridor Flow, our fabulous coffee shop around the corner, asked about what are the laws for paternity leave for part-time employees, and are there any state benefits that they can partake in?
So with part-time employees, the real test, it's going to be first CFRA, as we said, California Family Rights Act. So the employee has to have worked for you for at least 1,250 hours over the prior 12-month rolling cycle. So when we say part-time, they could maybe meet that test, maybe not. That's under CFRA. This is unpaid leave, but typically under CFRA, paternity could be a newborn baby or an adopted child. They are entitled potentially to up to those 12 weeks, separate and apart from any disability leave that the mother may have related to the pregnancy condition. This is unpaid leave unless the employer voluntarily provides paid leave, but there is some state disability available through the EDD that they can receive.
Okay. And I would be remiss if I didn't recognize some of the other folks on this call. Of course, we have our bakery right around the corner. Stephanie from Trim Tart is on the line, as well as Naeem from Lomita Post, Print and Parcel, Redwood's Pizza. We've got Adam Chiropractic, Risa. We've got Valerie. She's our notary person. And George, who's here helping EcoSpin Laundry down the street. So very localized small business group here. I did want to have Andrew McReynolds from Monarch Grove. Andrew, if you'd like to say a few words, just letting people know as one of our newer members. So welcome to him as a new member to the Lomita Chamber, what you offer in terms of resources to help employers and small businesses navigate some of these opportunities with the CalSavers piece, or even anything else in terms of retirement plans.
Yeah, I think the most pressing one, and nice to meet all of you. Yeah, I think one of the most pressing ones is CalSavers, because it's required by June 30th. So anybody that has 5 employees or more, and I think Scott hit on an important point, with tax time and everything else, a good amount of people are going to wait until the last minute. Also, there's a lot of business owners that just don't even have this on their radar. But yeah, they rolled it out. Prior year it was 100 employees, and now we're just down to 5. So if anybody has 5 or more employees, you'll have to get this implemented by the 30th. So yeah, the other thing Scott touched on, kind of the pros and cons there. It's basically a Roth IRA, for you and your employees, which, overall, I think it's a good thing. I think it's a good thing that, there's a lot of people that are missing out on retirement plans, and they're kind of, for better or for worse, forcing people's hand, in the small business owner space to get this done. On our side, we've done a lot, especially lately, of setting up qualified plans for business owners. We work with family owned and operated small businesses. And the plus side of setting up your own plan is tax deductions. So you can have tax deductions for yourself. You can also pre-tax a pretty significant amount of money, depending, what level you want to go up to. We were just working with a small business, and they were able to pre-tax up to $400,000, for qualified plans. 401ks, you guys are probably more familiar with. So you can do 401ks, profit sharings, and you can also do things literally quite simple as a simple IRA, where it doesn't require some of the admin or some of the costs there of the other options, but would qualify for the plan. And that way, you have a tax deduction, your employees have tax deduction. One last quick add-on, and I'll open it up to any questions. There's actually tax credits too. So to go hand in hand with the new requirement, if you do set up your own personal plan for a 401k or a profit sharing or the like, there is a tax credit that they're doing for the next 3 years that more or less pays for the cost. So it's $250 per employee. There's a little formula associated with it. It's like 50% of the cost plus $250 per employee. As long as they're not that high income category, like Scott mentioned, where it's $135,000 a year up to $199,000. But yeah, the short of that is, in the work we've done, it basically pays for the plan. So you can get a free plan, more or less, set up over the next 3 years as they're getting small business kind of up to speed for these kind of offerings. But yeah, it has to be done by the 30th. So anybody that wants to follow up, offline or has any questions, can reach out, and we can give you kind of quick feedback on what's available. But same rule applies if there's going to be a lot of people trying to do it within the same period of time. So, just keep that in mind.
Thank you, Andrew. Andrew, please, if you could put your contact information in the chat, that'd be great. And, one of the things that Andrew and I were talking about before today's session was, as employers, this is also an opportunity, right? So if there's a retirement savings component that you're required to provide in some way, shape, or form, this is an opportunity to be competitive in the marketplace when you're hiring people. And these are the things that I think employees are also looking towards as well when they want to work for an employer, is what benefits do I have? And obviously the tax deductions and things like that are always helpful. One last thing too, please do take a look at the chat, reach out to Chase Law group, and please utilize them as a resource. One of the things that the Chamber does behind the scenes with all of this, as you guys saw, we talked about Assembly Bill 5, all these different legislative initiatives and laws that get passed at Sacramento or at higher levels. the chamber's role as well as advocacy. And so a lot of these bills, as they come through, we are notified through our affiliation with the South Bay Association of Chambers of Commerce and hear about these changes that could be going across the desk of our legislators. And so we do advocate as much as possible, along with many of our other chambers of commerce nationally, and also in the state of California and locally in the South Bay, to really try to create and support an environment that stays business friendly. Sometimes that's always very challenging, just depending on how the pendulum swings. But that's why we're here to help you all with some of these shifts and adaptations. And we have resources at our fingertips. So reach out to the resources who are here today. If you have any other questions, you can also reach out to the chamber. Chances are, if I don't have the answer, and I'm not going to answer any of these legal questions or retirement savings questions, but I know somebody who does, and some of them are here today. So please utilize the chamber. I just want to take my hat off to everybody who is here today. We will have this recording up on the website. We'll share it with you as well. So if you didn't catch anything, but go directly to the source. The legal experts are here. The retirement savings folks are here. And please do keep your eye out for the next opportunity through the chamber, whether it's education or getting together to network, or some of our fantastic events happening in our community. Go to lomitachamber.org and stay on top of it. So any final words from our legal beagle speakers? Thank you so much. You guys did a great job.
Thanks for having us.
Yeah, thank you very much for having us. There's a lot of information out there, and we're just here to help support our local business community.
Awesome. Well, thank you guys so much. Thanks for being a resource to the chamber and our members here. I hope you all have a great day, and thanks for joining us.
Thanks, guys.